Hi students, Professor Orenberg here, and today we're going to talk about conditions of satisfaction, but in the context of going through a practice essay exam, like the ones you'd find on the bar or maybe your final exams. And the reason for this is twofold. First, our goal is to review and understand the substantive law of the condition of satisfaction doctrine. But second, and equally important, is to understand how to respond to a question on this topic in an exam format. So let's get started. Let's take a look at a bar exam question. Some of you may never have seen one of these before, so I'm going to give you the anatomy of a bar style exam question from the Pennsylvania bar exam. This is question number 5, which appeared on the 2015 July bar exam. And the first thing to note is that it begins with facts. Lots and lots of facts, organized into several paragraphs. And after the facts, you'll receive a set of questions. In this case, there are 4 questions. On the PA bar exam, that is the most common number of questions for a given set of facts. At first glance, this looks pretty overwhelming. Lots of facts followed by lots of detailed questions. What's the right way to approach this? Well, I'll start by giving you a little secret. Each of these set of questions, or each of these questions, sometimes they're a set, here there's, can be A and B within them. Each of these typically pertains to a paragraph in the facts. And moreover, the facts are organized so that the facts that you need to answer the question are typically going to be in the same order as the questions themselves. So really, the fact pattern doesn't look like this. Take a look at this. I've put the questions right after the facts that are required to answer them. And suddenly, the exam looks a lot more manageable. We can look at question 5 as having 4 separate interrogatories, which are typically separated by 4 separate fact patterns. So now we have really, within question 5, question 1, a short fact pattern followed by question 2, a short fact pattern followed by question 3, and a short fact pattern followed by question 4. Now again, isn't that much more comfortable than looking at this big block of multiple pages of text followed by 4 long questions? I think if you begin your exam by thinking about the bar exam in a more simple way, you'll feel less overwhelmed and more inclined to address it properly. Once you've broken it down into those constituent parts, you can now address each fact pattern and question in turn. We're going to take a deeper look at fact pattern 3 in my video on Conditions of Satisfaction, a practice essay. But I wanted to start out by just showing you that the bar exam might feel really daunting, but if you look at it as a series of 4 questions or interrogatories within each question, and you separate the facts out like this, you can all read a paragraph and answer a question about it. And hopefully that makes you feel more comfortable than looking at the entire bar exam writ large. And we're going to look at a question from the July 2015 bar exam in Pennsylvania. This was question number 5. And what I've done here is, on the Pennsylvania bar exam, there are 6 essay questions, but really there are 24, because each of these 6 questions has 4 interrogatories, and each of those interrogatories focuses only a subpart of the facts. So I've extracted the relevant facts from that long question, and what you see here are just the facts that are relevant to answering a specific question, particularly a question around conditions of satisfaction. Now, one thing I'd like to remind students is that you can get bogged down in the facts and maybe lose your way in terms of what you're supposed to be looking for. So you might want to begin by looking at the actual question. This was the question section of the exam. And if we take a look at the question, we can clearly identify that we're dealing with a contracts issue. It stipulates in the question that there is a breach of contract claim. So really our best bet here is dealing with that contract issue. And so now we know what to focus on when we read the prompt. Now that we know, based on the question presented, that we're supposed to be looking for a breach of contract claim and evaluate its merits, now we can read the fact pattern a little bit more surgically and try to figure out what we're trying to extract from it. So let's take a look. In August 2014, Charlie hired Bob and Carol to perform at Birdland, his big city jazz club, for 3 months at $1,000 a week. Now, again, we have our contract mindset as we look through this question. And the first thing I think of when I think of contracts and these sort of facts is that this is a contract for services. The UCC does not apply. So we should be analyzing this from the perspective of common law. The valid written contract between the parties contained an express condition that Charlie could immediately terminate the contract if he was not personally satisfied with the performance of Bob and Carol. Okay, now I can see that the issue here is we have a condition of satisfaction, or at least a termination clause issue, but it seems that this is both a termination clause issue combined with a condition of satisfaction, because the fact pattern goes out of its way to make it very clear that we have an express condition. A couple thoughts should come to mind right away with express conditions. First and foremost, express conditions need to be completely performed. Otherwise, the other party does not have a duty to be performed, which means in this case that, according to this contract, Charlie has to be completely satisfied and completely personally satisfied. And if he's not, he doesn't have to pay Bob and Carol $1,000. Let's look at the third set of sentence in the fact pattern. Bob and Carol's initial performance earned unanimous praise from big city's entertainment critics and a number of influential entertainment bloggers. Why is this being brought up? Well, this is a fact that shows that a reasonable person would think Bob and Carol had performed satisfactorily. Why is it talking about what other people think? Who cares what other people think? This is because conditions of satisfaction can be looked at objectively or subjectively. Subjective means that the individual who holds the condition has to be personally and actually satisfied, in fact, whereas objective satisfaction means that a reasonable person in the same circumstances would reasonably be satisfied. And this third sentence is getting to the point that a reasonable person would probably be satisfied because critics like this stuff. So we must be asked to deal with that tension between whether an objective or a subjective condition of satisfaction applies. Third sentence. Despite universal critical acclaim and steadily increasing attendance at their shows, Charlie said to Bob and Carol at the end of the second week of their performance, "Sorry, but I'm just not digging it from you cats. You're fired." Okay, this is just setting us up for the breach question. Charlie didn't perform his obligations to maintain Bob and Carol's employment for 3 months. He, after 2 weeks, terminated them. He does have a clause in his contract that says he can terminate them if he's not personally satisfied. And we have some additional facts that a reasonable person should be satisfied in this situation. Now that we understand the facts, let's take one more look at the prompt before we begin writing our answer. The question presents that Bob and Carol sue Charlie for breach of contract, and Charlie defends based upon his condition. So this must turn on that express condition of satisfaction. So we have to analyze whether or not this defense is going to work. At trial, Bob and Carol present evidence. Okay, pause here. Now remember, we are in the question section of the bar exam. And what's weird about this? We're getting a lot of new facts. And you know what? This is how it works on the bar exam. Sometimes there are facts contained in the question, which we need to consider as part of the overall facts just for this interrogatory. The reason the bar examiners do this is because these facts won't apply to, for example, question 1. They'll only apply to question 3 in this case, within that set of facts. These specific facts only deal with this particular interrogatory. At trial, Bob and Carol presented evidence that the agent for Alice, the recent winner of the TV show America's Most Idolized Voice, had contacted Charlie just before he fired them and promised Charlie that she would guarantee Charlie sellout attendance at triple the normal cost of admission if he would hire Alice to perform at Birdland during the period of Bob and Carol's contract. Why on earth is the examiners giving you this additional and lengthy fact? What is this getting at? Well, this is showing you something about Charlie's motivation. And one thing that we know about the condition of satisfaction is that although it's disfavored to treat it subjectively, it can be, we can allow a personal condition of satisfaction to stand, but there's still the doctrine of good faith and fair dealing. The fact that Charlie might have actually, in truth, been satisfied, but really just wanted to make more money by hiring Alice, and so he was going to throw Bob and Carol under the bus. That's an important fact that we'll have to attend to because it gets to whether or not Charlie acted in good faith when he terminated the contract. So let's just briefly review what we've learned so far. We know that we are dealing with contracts. We know we are dealing with express conditions. That was really presented to you clearly. The condition was a condition of satisfaction, so it's a specific type of condition. And we hopefully will remember that conditions of satisfaction can be objective or subjective. The objective approach is preferred, which means reasonable satisfaction, but the subjective approach can apply in certain areas, especially regarding personal taste, and when there's explicit language in the contract, which there was here. So we have to deal with that tension of whether the court should apply an objective or a subjective approach. We have some facts which suggest that if we take an objective approach, that Bob and Carol's performance was objectively satisfactory. And we have some additional facts that if we take a subjective approach, then Bob and Carol's performance might not have been pleasing to Charlie, but on the other hand, he might have been lying about whether he was satisfied because he wanted to get a better deal with Alice. So knowing all that, let's jump in and try to analyze this question in writing. First, we have to always remember what is the question that the examiners are asking, because at the end of the day, we have to answer that question. The question that the examiners asked us was to discuss the merits of Charlie's defense, and if we want to encapsulate that into an issue statement, we can focus on the condition of satisfaction. Charlie will be able to defend his claim if the condition of satisfaction was not satisfied, and he will lose if the condition was satisfied. So the issue is whether a condition of satisfaction is satisfied. Now we're going to run through the rules. This is our second letter in IRAC. IRAC stands for Issue, Rule, Application, Conclusion. I use the term under to signal to the examiners that I'm in the rules section of IRAC. Under common law, what do we know from common law? The duty to perform under a contract can be conditioned. It can be conditioned, among other things, on a party's subjective satisfaction. However, an objective interpretation is preferred where it is practicable. Now, on the bar exam, luckily, you don't have to cite the cases, so I'm not doing that here. If you'd like to see the examiner's analysis, you can go to the website of the PA Bar and you can look at all the citations for this law. I'm basically here just stating the law of the restatement and how Pennsylvania follows it, but I don't need to cite every case on the bar exam. So let's start interpreting the agreement. And we're going to begin by saying that we do have a valid written agreement. It appears to be final but not exclusive. And in these instances where we have a valid written agreement, courts will prefer to read it on its four corners, meaning they'll objectively interpret what it means. Now, by the way, it turns out that parole evidence doesn't really matter here. But in interpreting the contract, I just added a sentence that said, this contract appears to be final but not exclusive. I don't think I'd lose any points. In truth, it turned out that didn't matter, but it's okay so long as you don't go too far down rabbit holes. We'll talk about one of those rabbit holes at the end that some students may have gone down and wasted some time. All right, so now we understand we have a written agreement. We're going to try to evaluate it objectively. So let's do that. We'll analyze the term. The term that we have to read is personally satisfied. Personally satisfied does indicate an intention for a subjective condition of satisfaction. And the subject matter here is a musical performance, and that is one of the categories of contracts that is often going to be a matter of personal taste and therefore can't be practically evaluated objectively. Because what is a reasonable, good piece of music? It's like saying what is a reasonable, appealing color, or what is a reasonable favorite work of art? This is a matter of personal taste, and so on the letter of the agreement, from the objective standpoint, we begin by having a bias or a preference toward a subjective approach, even though the law would ask us to try hard to maintain objectivity. So let's next look at the circumstances, the extrinsic evidence, and apply some reason to it. This is a mix in the sense that this is a commercial agreement. It's about a club, and so what we assume Charlie cares about is profitability. This is not a jazz band for his daughter's wedding. This is a jazz band for his business. So that actually pushes us a little bit toward the objective realm. But once again, we're dealing with music, which, like art, is hard to evaluate objectively in terms of whether it's good or not. Not impossible, but maybe hard for a court to do. So the circumstances, the extrinsic evidence, might lend us to be a little bit more inclined toward an objective view as we kind of go through our analysis. Couple rules here. A condition of personal satisfaction will not be implied unless it's stated explicitly, although here it was. So we know that we need to have those magic words, and we had them here. If there is doubt or ambiguity as to which standard the parties intend to apply when a condition of satisfaction is stated in a contract, the preferred interpretation is for the application of an objective test of reasonable satisfaction. Again, what we're dealing with here is a preference for an objective standard, right? A preference, however, that could be overcome depending on the nature of the subject matter of the contract. What we're doing here, we're showing the examiners that we really understand that these rule examples, these specific rules, apply to the facts that we just mentioned, and we're going to need them to analyze a little more deeply. The preference for an objective standard may be overcome depending on the subject matter of the contract, and where the satisfaction regarding performance of a contractual duty relates to matters involving aesthetic qualities or personal fancy, taste, or judgment, the application of an objective test for satisfaction with the performance is not considered to be practicable. Here, it was very helpful if you remembered comment B from the restatement, because that comment said these exact words, which basically said, to put it in just a third way, we have a rebuttable presumption that conditions of satisfaction are objective. And here we need to see if we have rebutted that presumption. So let's apply the rules to our facts. Here, in these instances, under these facts, Charlie's agreement with Bob and Carol provides that Charlie's personal satisfaction is required. Therefore, as a matter of law, courts may apply a subjective standard, even if the terms are considered ambiguous, which I don't think they are. It says personal satisfaction, but you could make an argument that that was somewhat ambiguous. You would still have to look at the subject matter. This subject matter concerns music, the quality of which necessarily involves personal taste and judgment. So it may not be practicable to evaluate music objectively. So we have first set up our argument in favor of Charlie. And, Charlie is here saying, look, I have a condition of personal satisfaction. And the law seems to be somewhat critical of these types of conditions, but it permits them. And he has the magic words. He has the express language in his agreement. The subject matter of music is one which would often be evaluated subjectively. It's hard to evaluate objectively. But we should make arguments on both sides. So what do our what do our plaintiffs, Bob and Carol have to say about this? On the other hand, courts will make every effort to construe a subjective term as rather an objective one. And you can see that in Monogram Plus and in More in Building Products. Even when the term is used in the contract and makes explicit reference to personal satisfaction, courts might still construe it to be objectively. So who wins this dispute? Let's resolve it with our continued analysis. However, this case is not like Monogram, which dealt with a loan, which was commercial, or like Morin, which dealt with a warehouse, which is commercial. Music is fundamentally different from those subject matters. Additionally, the Monogram dissent argued that the loan terms did not practicably lend themselves to an objective analysis, showing that even loans could potentially be evaluated subjectively. So really, after we've weighed and balanced those arguments and applied the law to the facts at hand, brought up a couple analogies, I think we can conclude on the main point, which is it is most likely that Charlie's personal subjective satisfaction is required. And so we now have to connect this main point, right? Whether, kind of subpoint one, what was the nature of the condition? We determined that nature was a condition of subjective satisfaction. So now let's connect that to whether he was actually satisfied, because that's the standard. A condition of personal or subjective satisfaction requires the party who holds the condition to be actually satisfied. And we have some facts here that Charlie might not have been acting in good faith when he said he wasn't happy with their performance. So the rule, this is just the issue statement, right? So then we go into the rule statement. The rule is that under common law, if the condition in the agreement is clear that only honest satisfaction with the performance is required. The condition will not occur as long as the promisor is honestly dissatisfied with the performance, even though the dissatisfaction may be unreasonable. This again would be helpful if you remembered the restatement for this rule explanation, but you could also reason to this because the restatement provides a rebuttable presumption that conditions of satisfaction are measured objectively. But of course, a rebuttable presumption can be rebutted, and when there is sufficient evidence that this is a subjective condition of satisfaction, then we have to look at whether the person was actually satisfied. And here we have some Pennsylvania law. Whether there is a bona fide dissatisfaction is a question of fact. We may not have the answer to that question, and we don't have all the facts, but we can still answer the examiner's question as to whether his defense will succeed by saying, well, it might depend on how a jury will evaluate certain things. That's an acceptable answer. Let's see how we go with this analysis. So here's the rule. Let's apply it. What are the key facts that have to do with Charlie's good faith? Here, another singer contacted Charlie just before he fired Bob and Carol. The other singer guaranteed to outsell Bob and Carol. This should be troubling. This should be concerning to us because this might show that Charlie had a bad reason to fire Bob and Carol. He liked their music, but he wanted more money. That's what that fact was in the fact pattern to do, to bring us to this point. Let's apply it. Charlie's dissatisfaction, first off, was unreasonable. And although he's entitled to be unreasonably dissatisfied, this matters because it tends to show he's not acting in good faith. Why is he dissatisfied when the world thinks that this is wonderful music? This makes him more susceptible to alternative explanations for his behavior. So while Charlie is entitled to a subjective condition of dissatisfaction, the objective unreasonableness of his behavior tends to show that he's acting weirdly, not in good faith, not acting honestly. Therefore, Bob and Carol have a strong argument that Charlie was not actually dissatisfied, but was rather acting in bad faith in order to get a better deal from someone else. Therefore, a fact finder will have to decide what Charlie honestly believed. Again, we don't know what Charlie believed, but we have now pointed out to the examiners that we understand that is the key fact at issue, and we've shown we understand Pennsylvania law in that a fact finder will have to determine that. So it might have to go to trial, or it might have to be resolved, if it can be resolved at summary judgment. So this is a great answer to the question, except we want to go back to the beginning now that we finished our analysis and really show off to the examiners that we know exactly what they were asking and how to answer it. And what I recommend is you answer the question once you've done your writing at the very beginning of your essay. And I would start my essay. I won't start the writing process, but once I've finished, I will put at the top, above my IRAC, my answer. If Charlie's dissatisfaction was prompted by bad faith, his defense will fail as a matter of law. And we don't know the answer to whether he was acting in bad faith or not, but through our analysis, we will show the examiners how we get there. What are some other arguments we could make? Are they good to make? Well, I thought of some other things. I mentioned that parole evidence kind of came up because we had a writing. Should I have talked about parole evidence? Or how about defense? Should we excuse Bob and Carol? We could have made this argument too. Even if Charlie's claim succeeds as a matter of law, Bob and Carol could raise the equitable defense of excuse from this condition. Well, I'll tell you what, guys. The bar exam tends to be pretty focused. This was a really focused question. And the key thing is to identify the exact issue and bang on, hit the nail on the head. Sometimes the bar exam will ask you in one interrogatory 2 separate issues to deal with. Rarely does it do that, and very infrequently does it go to 3. We've identified the key issue, and we use the specific facts to tell us about this. We don't have a lot of facts about excuse that would pertain to excuse. If the examiners didn't give us those facts, this might not be the best use of our time. Should you raise this argument? Should you raise parole evidence? Should you raise, well, if you're nervous, you'll try to raise everything, but you're going to have a very limited amount of time on this exam. It's okay to raise some additional arguments, but only if you have time. Because if you raise an argument in question 5, interrogatory 3, at the expense of addressing question 6 at all, that's a poor use of your time. On the other hand, if you finish the exam early and you have a couple other things to mention, and then you can go back and deal with things that are supported by the facts. So briefly, just for those who are curious, like how does the excuse defense play out here? Well, the rule for excuse is a court can excuse the non-occurrence of a non-material condition to avoid a disproportionate forfeiture. So let's take a look. What's the forfeiture? Bob and Carol, we could surmise, would may forfeit their expectancy in future performance, especially if they had invested in their fan base. But they were paid for the performances that they had, and we have no facts to say they can't get another job. Maybe they could get another job getting paid more. They don't have to perform, and they won't be paid, so there's not necessarily forfeiture here. And Charlie might be harmed as well. So I don't know that it's totally disproportionate. He's a club owner. He has a certain aesthetic that he wants to provide in his club. And he might be harmed by promoting some cats he's not digging, according to these facts. So we don't have strong facts, but we can do a little analysis. Excuse is not permissible when the condition is material. And here, this is the big problem why it turns out this wasn't a great argument to raise. The express condition of satisfaction seems to be an essential part or the essential part of the agreement. The fact pattern made it front and center and told you there's an express condition. For us to argue now that the condition of satisfaction was immaterial, therefore it is unlikely for Bob and Carol to prevail in a court to excuse the non-occurrence of Charlie's condition of personal satisfaction. In other words, we went through this whole analysis only to say that the defense probably won't work. So was it worth spending your time on this? Well, I'll tell you what, on the bar exam, you would have gotten no points for dealing with excuse. On a law school exam, you could get a few points, but what did it cost you? It's not a free lunch. Did you spend adequate time on the primary issue, or did you rush your analysis and miss key points of the primary issue and some of that logical steps in order to get to a broad, approach by focusing other issues? Did you earn all the points before moving on, and did you have enough time for the other questions? If you did, cool, fine, no problem. You mentioned a few extra things. It's not going to hurt you. But most students aren't able to do that effectively, and the bar exam is very time pressured, as are many law school exams. So with that, feel free to comment if you have any questions or thoughts about this approach to practice essays on the bar exam. Good luck on your exams.